should be going up live now. I know there's usually a delay, so although I will be talking to you, it's probably about 5 seconds behind. My name is Tony DiUlio. I am one of the partners and owners of Wheeler, DiUlio, and Barnaby. It's a good WDB legal there. And I'm doing these lunch and learns, hopefully you've been watching in the past, to try and just get information out to the industry so that we as an industry can push back against the monolith insurance companies that are out there. I know there's often this feeling that it is, all the adjusters, every man for themselves kind of mentality. But the truth is that we have to have some organized approach to push back on what these carriers are doing. So I try and do these lunch and learns to give you an opportunity to learn some more about the industry at no cost to you. Originally, I was going to try and do these back in the day in person. COVID changed all that, but it seems to be working well to be doing it remotely. Today's topic is Adjusting 101. And I spent a lot of time with my partner Mario talking about what our next topic should be. And what we keep seeing over and over is that a lot of adjusters are missing some of the very basic aspects of claims adjusting. And so once we do get a file in litigation, it becomes problematic because things are missing that should be in there. It's not organized correctly. There wasn't proper correspondence. Multiple issues that should really be handled during the claims adjustment process. So that's what we're going to discuss today. If you haven't seen prior lunch and learns, go back on our Facebook page, and we're also trying to get them onto our web page, although it's causing us some issues just with tech. But go back on our web page for Facebook, and you can check out all of our prior lunch and learns. There's some really great topics on there that I think you could find to be extremely helpful. So feel free to go back, watch them anytime. And if you've ever got additional questions on things you have read one way or another, you can reach me anytime. This information down here is my personal cell phone number and my email address. So give me a call, shoot me an email, whatever you need to do, and feel free to ask any questions. I am busy often, so if you try and reach me on my cell and can't get me, it's probably best just to send me a text message. It gives me something to make sure I'm following up on. So take that information down. I'll have it again at the end of the presentation. So today, we are going to learn some interesting stuff about claims adjustment. Some of this, hopefully you already know. Candidly, I hope all of you know this already, but I think you're going to find that a lot of this information are kind of basic things that you really should be implementing. And part of this might be, oh look, I've always kind of known I should do that, but I've never implemented it. Hopefully we can start discussing some of the reasons why that's so important today. Just like all of the lunch and learns, if you have any questions, please type them into the moderated chat. My partner Mario is behind the screen right now. He will be updating the question slides with any additional questions that you guys might have. And then if there's something he can respond in chat, we will do that too. We actually run this on 2 computers, so we have a silent keyboard on one of them now, so hopefully the keyboard problem isn't an issue as it has been in the past, but let us know. So we're going to talk about these tips today: signing the claims up, the organization of your claims file internally, the documentation for the claim, the presentation, and the negotiations. So we're going to go through all of this, and hopefully you guys can get something good out of that. One thing that I say in all of these is that you really should look into joining a local organization. There are groups all across the country. The one locally to me is MAPIA, which is the Mid-Atlantic Public Insurance Adjusters Association. And they are really great organizations, not only for information, but also for support. So by joining MAPIA, for example, you get a lot of great things. You get free CE credits that we offer. We're doing a holiday party that's coming up where I do a free happy hour for everybody. You can drink to your heart's content. We do live Q&As with myself, other attorneys, like Holly Soffer, who is fantastic when it comes to contract issues and licensing. And then support for the industry through lobbying. And that's another really big one, because you've got to recognize we are up against these giant corporations. Insurance companies are one of the most funded corporations in the world, so we are trying to push back. And the only way that we can prevent certain legislation from coming through is through lobbying efforts of our own. So joining those organizations is very inexpensive. It is tax deductible. There's no reason not to do it. And you get a lot more information than just the basic stuff that I do in these lunch and learns. So think about doing that. The other thing that I say in every single presentation I give as a disclaimer, I really don't want you to have to send me cases. And I mean that. One of the purposes of these lunch and learns is so that you don't have to send claims to litigation. Hopefully, you can learn tricks in adjustment and learn about the law and learn tools that make these claims go faster, get higher results, and don't ultimately have to be sent to litigation. However, if you ever have any questions or need a claim to go to litigation, feel free to reach out. I've expanded my practice extensively throughout the country. I've got claims all across the continental U.S. If you have a claim in Ohio or in Hawaii and you want me to come out, feel free to ask me. No problem. We'll take a flight out. Been looking for an excuse to get there. So let me know though. Really, I'm happy to answer questions, and I do it really all over the place at this point. So let's jump in, because the other aspect of this is today we're going to have a relatively harder stop on timing, only because I have a deposition that's going to start at 1:30 today. So, signing the claim. This is actually one of the most important parts of the claims process, not because it has any impact really on the result of the claim, but it has a huge impact on protecting you as the public adjuster, both with the insured and with places like the insurance department, who might ultimately conduct an investigation. And really, what all this comes down to is the signing of your contract, what is in your contract, and when it is signed. What you're going to want to look for is any state regulation in your specific state as to what must be contained in the contract. Now, that might sound simple, right? A contract, there's nothing too complex. You put some, your date and times, your company names, license number, fee percentage, cancellation provision, you're good to go. The truth is there's a number of states that have very strict requirements. Some states even tell you the actual contract you have to use. And there are some of those states that say you can't change this contract at all. This is it. This is what you get. Go ahead and use it. Truthfully, those states are some of the best because it makes it very easy to know if you're complying or not complying. This is contrary to other states, like in New Jersey, where they give you this kind of broad language and have expectations, but will never actually tell you if you want to, if your contract complies or not. So you might be, being investigated by the Department of Insurance, have no idea, and be trying to ask them if this is good enough, and they won't tell you. So that's one of the things that our groups can help with. Is Mapia, for example, reaches out to the New Jersey Department of Banking and Insurance, and we are trying to get some of those regulations changed regarding the contract to protect the industry as a whole. But you want to make sure that you are compliant with that, whatever that law is regarding the contract. It seems minor, I understand that. And here's the real problem. It doesn't even take a complaint from the property owner to get you investigated. It could be something from the insurance company where they've got some issue and they send it in, and then all of a sudden, if they've got a problem with the homeowner, let's say, and they file a claim against the homeowner with Department of Banking and Insurance, now the department has the right to investigate your claims file, get your documents, and all of a sudden you're starting to be investigated despite you doing nothing wrong. No one had a complaint against you, but they're looking into it anyway. So you want to be very, very careful with that. On any contracting or licensing issue, if you haven't had your contract reviewed by an attorney, you should. If you have questions about how to get licensed in other states, speak to an attorney. These are really important things. Another great disclaimer, not my area of specialty. I don't really do much. I do a little bit, but not much when it comes to the contracting and licensing side of public insurance adjusters. I know a fantastic attorney who works pretty much in every state of the country that does this, and I will be happy to send you to her, but you really need somebody to take a look at this stuff. It can make all of the difference. You do not want to be somebody who gets that notice from the department that says, hey, you're under investigation for these violations. We need some more information from you. That is not a fun letter to get. So make sure that you are compliant. Super easy. Also, one thing to always know when it comes to date and time, there are a number of states that have regulations as to when you can sign claims up. So make sure that when that information is placed into your contract, you're complying with the state law regarding when contracts are allowed to be signed, and in essence, in relation to the time of the loss. A lot of places don't let you sign claims after 5 or 6 p.m. within 3 days of the loss, things like that. So make sure that you are compliant with those. It'll save you a ton of headaches down the road. All right, so That one was easy. That's the kind of breeze past it because it's simple but important aspect of this presentation. The next is your claim organization. Now, this process is really about what does your internal side look like for claims. And a lot of you might have some very old school tactics, which by that I mean you've got a file folder, you write notes on the cover, you keep documents in there, and that's about it. The truth is, in modern technology and the way the world is moving today, there are a lot of options out there for more advanced systems that will really save you a lot of time and ultimately make you more money. There's the old adage, time is money, and that is just as true for public adjusters as it is for attorneys, contractors, anyone else out there. The reason these software programs can be so fantastic is because they can automate a lot of things. So let's talk about generally what you're going to want to be looking for. Your management system should always track the important dates of a claim. And it's not just as easy as saying date of loss, suit limitation provision, end of story. There's a lot of dates in there. And if you go back and watch, for example, our Lunch and Learn on Unfair Claims Practices Act for your local states, you're going to see there's a ton of timelines that are given by state law as to when carriers have to do certain things. You should have those dates within your system. Within your system, you should maintain all of your communications with the carrier and any attempted communications. I don't know if everyone on this call has seen a claims log from the insurance company, but it outlines day by day everything that is done on a file. Incoming call from adjuster, discussed this. Outgoing call, left voice message about this. Had inspection, talked about that. Those claims logs make a huge difference in how a claim will ultimately be resolved in the end for everybody involved. And I know it might seem like that's not a very big deal for you, but what's happening, and I'm sure you have seen this in the industry, is carriers have been starting to switch adjusters. So you could be, 4 months into a claim, oh, that person's left on maternity leave, and now we have to assign somebody new. It's unbelievable, by the way, the amount of people that seem to get pregnant at insurance companies and all of a sudden have to leave for maternity leave seems to be a very common issue, surprisingly. But the truth is they're just doing it to delay these claims and to reopen investigations and slow everybody down. So if you have a good log of that, you can use that as evidence to show, hey, I've already given you this stuff, you've got no basis for this delay, and we need to get a resolution much faster. So it's not just the actual communications, but the attempts as well. You obviously want to maintain all of your important documents. This should be second nature, right? If you receive something from the insurance company, it should be in your file. If you send something to the insurance company, it should be in your file. If your insured sends you something, it should be in your file. It's amazing how often I will get a file from an adjuster that just doesn't maintain these records. I don't understand it. I don't know where they're going, but you need to be keeping them in your file. The automation is what can be really helpful here. There are a ton of software programs, both specific to claims adjusting and generalized for businesses, that can help you with an automated system for your claims process. I know it might sound complicated up front and like it could be expensive. The truth is they're not that expensive anymore. You get monthly subscriptions to them, and we're talking, $30 a user, $20 a user, maybe $50 a user. I mean, this isn't anything that's going to really break the bank. And they can be unbelievably helpful once you get them set up properly. And the other thing is they are very user friendly. I have a number of people in my office who are a bit older, and they've pushed back pretty heavily when we first got these automated claims management systems. But the truth is they've all picked up on it because it's so user friendly. You should not be afraid of it, but it can help a ton making sure that you're not missing the important dates and automating so much, automating letters to go out, automating follow-ups. I mean, it's really fantastic. So I want to give you an example. This is by no means an exclusive list for a timeline that you should have in your claims file. And this is something that you should maintain. Now, every state's going to be different because some of this is dependent on your local laws, but you're going to want to take a look and find out, all right, what different timelines do I have, different deadlines for these claims? So we want to take a list in two parts. First is what you're doing on any given loss, right? So first thing on every claim, you're going to have a signed claim, right? first thing you need to do, obviously, is going to be sign the contract of the claim. You don't want to be doing work on it before the contract is actually signed for a number of reasons. A, most states have a 3-day cancellation period. You don't want to, ultimately expand that even further because they're going to get 3 days from the signing. But you also don't want to have any claims against you that you're representing and insured that you're not allowed to do. So you sign the claim, you report the loss within 1 day, right? You want to get that out the door. The claims timer starts when that report goes in, so you don't want to delay there. Similar for me in filing a lawsuit, right? Sure, I've got a statute of limitations. I might have 8 months before I have to file, but I know litigation can take a long time. The sooner I get that complaint in, the sooner that timer gets moving. Then within 2 to 3 days, you're going to document the loss. You're going to go out, inspect, investigate, get all the information together that you need that will ultimately be presented to the carrier. Then within 2 to 3 days of that, you want to schedule your joint inspection. And then this is one of the important ones that's going to come up a few times in the talk. But within 1 day of your site inspection, you should be sending out a summary of the inspection to the carrier. You want to do a letter out to them that says, all right, carrier, we did this during the inspection. We agreed on X, Y, and Z things. I appreciate that. That letter is one of the biggest game changers that I can see adjusters actually do in the field that makes a real difference in how the claim is ultimately paid, and even if it gets to litigation, in assisting with things like the bad faith claim. Every insurance adjuster, every public adjuster that I work with always tells me, hey Tony, I've got a great bad faith case for you. The truth is, a lot of them aren't great bad faith cases. And it's because they're missing things like the claims inspection letter. And if you send out that summary, then you have an opportunity to actually document this is what we talked about. And your letter or email, by the way, should always end, if any of this is incorrect, please let me know within the next 5 or 10 business days. Otherwise, I'll assume we're in agreement. And you want to do that because I know a number of you have dealt with claims where the adjuster says one thing in the field and then sends you an estimate for something else. So you always want to send out that summary of the inspection letter. And then you want to get your follow-ups, right? You want to put pressure on the carrier to make sure that they're not just leaving this by. This is where that automation system can be so helpful, because what you can ultimately get is a system that automatically sends out these emails or drafts these letters so that you or your office staff can just throw it in an envelope and send it out, or put it in an email and get it out the door. So either way, that can become very simple to do. So it's not like this, oh, I've got to do another claims update letter. And then you need your follow-ups after that initial one as often as you can manage, because the truth is it's the squeaky wheel that gets the oil. So this is a very short version, but this is what you're going to want to look to do within your claims office to make sure that these steps are all happening. On top of this, you want an important date tracker for all of your claims. And these dates mostly come from statute. So again, if you haven't seen that unfair claims practices talk I did, check it out. I think it was 1 or 2 ago on the list. But you're going to want to make sure that you have dates for 10 days from the claim acceptance. They have 10 days from you reporting the loss to send acknowledgement of the claim. They have 10 days to respond to any communications that you send to their office. This is for PA, by the way, so make sure that you're checking your specific state. 30 days for an initial position letter. That means within 30 days, they must send either a denial letter, a coverage letter, or a letter explaining why more time is necessary. What people miss constantly in Pennsylvania, by way of example, they have to tell you when an expected decision is going to be made. Now, I have never, not once, have I seen in a letter that is that, general 30 or 45 day update letter, have I ever seen a carrier say, and we expect an answer to you within the next 20 days. It doesn't happen. And this is something that you can push back on if you know the law and have it as part of your system. That same rule applies to the 45-day letters. Note in Pennsylvania, 15 days for a response to a proof of loss, meaning they've either got to deny the claim or cover the claim, or they're going to try to reject the proof of loss, which isn't actually a thing, but they try to do it anyways. And another great one to be tracking on your files is the 60 days prior to statute of limitations notice. So in Pennsylvania, 60 days before that suit limitation time runs up, they've had to have notified you. Now that could be the very first letter, that could be, the denial letter that was 6 months ago, but at some point they have to put you on notice that when that suit limitation is going to run, and it's got to be at least 60 days beforehand. Now all of this stuff, this feels like a ton of things to worry about for a claim, and I get that. But if you create a system that allows you to just automate so much of this, you don't have to worry about it. Not to mention, with the volume that I know a lot of you guys are doing, this will become second nature. You've just got to get into the habit. And starting that habit, it's tough. I know that, but it's worth it, and it will make a difference. If you start going back to them and be able to show them, hey, it's day 11 and you haven't responded to my communications, that's the type of stuff that wakes them up when you're all of a sudden citing the Unfair Claims Practices Act. Something to keep in mind. All right. So we've talked about the internal system. We've talked about signing up the claim. I want to talk about documenting the loss. This one, again, to me feels like it should be second nature, but it's just not happening on every claim. You should always have a copy of the policy, every claim. And the reason is insurance policies are unique. You know that. You know every policy is different, and they're changing more and more often and more drastically. So back in the day when you could get the Allstate HO3, you were pretty confident it was the same HO3 that you could get in, any two properties across the state. Nowadays, that's just not the case. Companies are constantly changing. I've got the deposition this afternoon in a farmer's case where they've gone from the farmer's standard HO3 to the smart home and then to the smart plan. And we've got to discuss all of that. I mean, it's crazy what they are doing out there. So you want to get a copy of the policy. I've said it before and I'll say it again. If they're not providing it for you, make a complaint to the insurance department. They will get you the policy because they have to. It is regulated by the states that they must provide that documentation to the homeowner. Photos. This is another one. Blows my mind. All of us, right in our pockets, have cameras more advanced than pretty much anybody has ever had in the history of mankind a decade ago or more. Use these. Use them to your advantage so you can document the loss. And what you want to do is take your wide shot first and then your close-up. And the reason being is if you take this wall, for example, I'm not sure if you can see this low or not in the camera. Can you see this, Maura? Not really?
Delay.
Oh, yeah, the delay in the video. So there's a spot down here on the wall. It doesn't look very good. It's got, it's a little sticky. I'm not really sure what it is, to be honest. But if I took a close-up of this picture from right here and just showed you a nice good shot of that, you'd have no idea where that is, right? It could be on the walls over here. There's a ton of white walls in my office. It could be down a hallway. It could be in a different room. It doesn't help me if it's here. But if I take the wide angle shot first and then come in and have the close-up to show the detail, now all of a sudden I can document in the photographs exactly where the damage is and exactly what that damage looks like. It doesn't take much time. You could do a video for all I care while you're doing your inspection. Just have your camera up. You get the rooms. You do the close-ups. All is well with the world. But you need to get that documentation. And I get adjusters who tell me all the time, oh, well, the carrier's taking their photos. I'll just use them. That's crazy. The insurance company is taking photos that will look good for them. They want to document the loss their way. Your job is to document it the right way. And to do that, you need to take your own photographs. Again, video is also very, very helpful. An estimate. Another one that blows my mind. And I'm sorry if I'm telling you things that are so obvious right now. You can tune me out for a minute because the fact that every claim I get doesn't have an estimate on it really is crazy. If you don't have an estimate on a loss, how do you know what the carrier is doing is wrong? They've underpaid a loss, right? You could sure have a gut feeling on it, that's fine. But you need to be able to document it. And more importantly, you want to show that the carrier has seen that estimate before because you want to give it to them to ultimately say, hey carrier, here's what I'm ultimately asking for. Why isn't this owed? There are a ton of statutes that, for New Jersey, for example, that says, hey, insurance company, here's what I want. You're saying it's not covered. What would make this covered? What do I have to prove to you to make this covered? And they have to give you that answer. So if you give them the estimate and ask them for that, you're going to have a huge leg up to say, okay, well, what's it going to take? Here it is. You should be estimating every loss. Now, there is a pretty hot debate that I've heard between whether or not you give the estimate first or you wait for the carrier to estimate first? I don't know the right answer to that. I'd be interested to see what your guys' thoughts are, and if you want to throw that into the chat just for my own edification, please do, because I'm curious what is being done out there as a whole. But the truth is, one way or another, that estimate should be created. Okay, invoices, receipts out of pockets. Pretty common one for obvious reasons, right? You need to show the carrier what has already been paid for when it comes to a loss to get the reimbursement. Generally, there are some exceptions actually, but generally the insured is only going to be owed what they spent. Now, if they've got invoices for remediation work, that's what they're going to be claiming from the carrier. So you want to make sure that those are maintained in your file. And it's nice to think, well, if the insured sent it to me before, they're going to keep a copy. I don't have to worry about it. The truth is, that's not always true. You can't really trust these homeowners to maintain their own records because they're just not very good at it. So you want to have them because ultimately, if you need it down the road, and this happens to me constantly, I'll reach out to a client and say, hey, do you have X, Y, and Z? Oh, I sent it to my adjuster. He has it. Sorry, he doesn't seem to have it. Can you resend me a copy? And then, all hell breaks loose trying to figure out where these documents are. So you want to make sure that you keep that for presentation. All correspondence, the denial letter and your rebuttal letter, another thing that we're going to talk about at least twice today. You need to keep these documents in your file. If you're having communication via email, you've got to be saving the emails. It becomes difficult with emails, and I get that because how long chains can get and saving over old chains. But the point is you need to figure out a system to make sure those emails are saved. Now I've got the rebuttal on here. Every single file that has a denial letter of something that you want claimed should have a rebuttal. And it should be a letter that is written or an email that explains to the carrier what you are claiming, why you are claiming it, and why it's covered. So you need to have that every single time, especially if it's something you're going to be pushing to litigation or appraisal for that matter, because you want that evidence that you've given them notice of the problem, you've explained it to them, and they've continued to ignore it. You want to prove a bad faith claim? Have your rebuttal letter ready, because it does everything that I need to do to prove that they had knowledge and ignored it. Supporting documents. It's often that adjusters seem to be missing these. You've got a hail claim. You should have a weather report that shows the hail. Perfect world, you've got a homeowner that took video or pictures of it, but the truth is not everybody does that, or they don't catch it in time. Hail melts kind of quickly. So you want to make sure that you're getting that. If you've got a roofing claim that is, and you're not an expert in roofing, and that's perfectly fine. You need to get a roofer out there to come in and say, hey, here's where the wind damage is, here's what caused it, here's what it looks like, and here's why it can't be repaired, it needs to be replaced. You want to get that to explain it to the carrier, to show them that you're doing your job to present the loss. So bring in those experts, spend that little extra money to make a lot more on the back end. Those experts can make a huge, huge difference. It's not good enough with these expert reports to just have something really general. Now, this happens all the time with roof, where I'll get an invoice from the roofer that says roof damaged by wind, and here's what the repair needs to be. That's not good enough to really prove anything. What is the wind damage? Missing shingles, torn shingles, where the seal's broken and debris put underneath, whether they're scissoring or zippering, I'm sorry. What is the issue here that ultimately needs to be paid for? They should not only document it with their words, but obviously also with their photographs. So make sure all of that is something that can be presented to the carrier. Now, to me, these are really must-haves in your file. I can't think of one of these things, maybe supporting docs depending on the loss that you might not need, but everything else needs to be included in your file every time. Just make it your habit. Create a checklist. What I do in my office, we have a checklist for the necessary items, and if we don't have it, we have to go get it, because I know that we need these to be successful on our claims. One more. Organized by coverage within the file. Organization of your internal file is up to you. I get that, but there are right ways and wrong ways to do this. Putting everything into one file doesn't help anybody. So when you're organizing it, you should have it organized based off of structure damage, contents, ALE. That's a really basic way, and it's really straightforward, so that you're not mixing up different pieces of evidence that you're presenting to the carrier when it comes to estimates, photographs, receipts, whatever the case may be. It's also going to help you a lot down the road when you're trying to organize your rebuttal letters, your claim presentation letters, your estimates, whatever the case may be, so it's all in one spot. What people don't recognize when they're thinking about these systems is they think how long it's going to take to set this up, and then how long the usage is going to be as a result of doing this every time. The truth is, once the system is set up, this is very fast, and you're going to ultimately save time because you're not digging through everything to try and get find a document or summarize something. It makes it a ton faster. Can't stress that enough. All right, so our claim presentation. Now this is going to be, what are you giving to the carrier to ultimately make their decisions? First, you want to do as much of your claims presentation in person as you can. And the reason being is you get a lot better response from people when you are in person. I believe it's actually even written on one of my slides that you get more bees with honey than vinegar. So you want to have a good opportunity to do this in person to make sure that you're getting a good response from the adjuster. Truth is, it's harder to say no to somebody when you're looking them in the eye than if you're just writing a response via email. So do your claims presentations in person and together. Next, you're going to document the inspection if possible. Now, what do I mean by that? First, we talked about the claims summary or the inspection summary letter. You're going to want to create a summary of whatever happened at the inspection. And there's a ton of ways to do this, right? You can do it via audio on your phone, create a recorded file and say, hey, just did inspection with X, almost like you're dictating. I did inspection with X adjuster. We discussed, A, B, and C things, said he's going to cover this, has some concerns about that, but we're going to get him, these things, and everything's done. Great, that does the trick, and you've done a great job of documenting it as soon after the inspection as you can. The other options you have are videotaping or recording audio files of the inspections themselves. Now, number one caveat, some states require the authorization of whoever you are recording to actually do it in a recording either in person, over the phone, or audio. So you want to make sure that you are complying with whatever your state law is as to that. Now, there's absolutely nothing in the policy that says you can't record an inspection. And this can create some animosity. So there is a line you want to toe here, because I still stand by the fact you will get more bees with honey than vinegar, meaning you'll get better results with people you are friendly with than the ones you're contentious with. So if you feel like it is going to be a contentious issue, just make sure you're playing your cards right. But the truth is, they can't really stop you from doing it because they have to inspect, they have to allow you there, and if you want to record it at the homeowner's request, there's really nothing they can do to stop it because, again, they have to ultimately be there. So you want to document that inspection. You want to do this early. The earlier the better. Most states have regulations regarding how soon after a reported loss the carrier has to be out there to inspect. Most of the time it's 10 or 14 days, which means they can't be pushing these things off a month simply because it's a hurricane and they can't get anybody out there. They have to get somebody out to inspect this loss, so you've got to give them the ability to do that. You really want to do it sooner rather than later. The reason being, damages change over time. You should know this as well as anybody, but water losses can look a lot worse on day 14 than they did on day 2. And if it looks too bad, all of a sudden you've got this issue of, is this a long-term leak or not? You don't want mold to start. You don't want these other issues, so you want to get out there early. When you do your inspection and you present your claim, you want to have your proofs ready. If you do the work for them, I have generally seen this to be true, and if someone has a huge disagreement, I would love to hear it, but generally, if you do the work for them, meaning you give them the evidence of the hail from the start, you give them the evidence of the plumbing leak through the plumber's report, you give them your estimate and give them the damages to say, look, you don't have to worry about writing an estimate, I got it done. If you do all of this for them, have the roofer inspect, have an engineer out there, and it's done and ready to go, they're much, much more likely to say, you know what, I'm not going to waste the money or time on this. They seem like a reliable expert. I'm good to go. Now, of course, this doesn't work all the time. I recognize there's always going to be the contentious people out there. But the truth is, it can help a lot. So you want to have those proofs ready when you are presenting these claims. The other aspect is, if you get this out of the way, it limits a lot of the work you have to do down the road. So if you front load the work that you've got to do on this, the remainder of the claim becomes a lot easier, and it's not issues you need to stress about after the fact. The longer a claim goes on, the more difficult it is going to become. There's no question about that. Memories change, priorities change, losses change, homeowner. I mean, there's so many variables. So if you front load that work and all you're doing down the road is follow up, your life is going to be a lot easier. You're going to save a lot of time and ultimately, hopefully, make more money from that. You want to follow up with that summary. And you're going to want to do that on any inspection that you have with a carrier, whether that be an engineer, their roofer, or the adjuster themselves. You want to have that follow-up every single time to document exactly what happened. And if you end with that language that says, in essence, if you disagree with any of the above, please let me know within the next 10 business days. Otherwise, we'll assume you're in agreement. That language really will help protect you and get quicker responses from the carrier. Follow up on responses often, at most every 10 business days. And the reason for that is almost every state has a 10-day requirement for when carriers have to respond to you. So you want to be following up with them on that 10th day saying, hey, I still haven't gotten my response. You need to do that because you're just documenting their problems with the file, all the problems they are creating. Everybody knows they're trying to delay these claims as much as they can. So we want to document that because what happens is we make these claims of, oh, they're doing X, Y, and Z thing. They're not responding. I'm calling them. They're not following up. But we've got no documentation for it. So you want to make sure that that is something that is in writing and to them. Again, writing counts for email or letter. So whatever you prefer, you can do it that way. Candidly, even text counts. All right, claims negotiations. So I actually did a whole class on this at the MAPIA meeting. And if you join MAPIA, you get that kind of content, which is much more detailed and involved. But I'm just giving a brief summary, but just another benefit of joining organizations like that. So you want to read this book. This is a really great starter book on negotiations. And candidly, it'll do a lot better job of explaining some of this than I ever would because he's a professional. But the book is called Never Split the Difference. I'm going to show you a picture of it on the next slide. Second, you want to do this in person. If you can't do it in person, you want to do it on the phone. If you absolutely can't do it in person or on the phone, then you've got to resort to email, then so be it. But the truth is, you are going to get better results in negotiating claims. Anyone who's been doing this for a long time will remember the days when you would meet up for lunch to discuss a claim and it'd be resolved by the time you got the check. And that happens because when people are just communicating in person, you're getting a lot more done, you're getting a lot further than you ever will in an email. People are very cold in emails. It's just a quick response. They think nothing of it. It's like, writing on the internet for your comments, right? People put comments on the internet all the time, things that they would never in a billion years say to somebody's face. But they're comfortable doing it on the internet because there's no repercussions. Email's not that much different. So you're going to want to take a real hard look at your claims and say, what can I do to have these conversations in person or at least over the phone? Anchoring. You want to send an anchor at your inspections. Generally, anchoring means you're giving them kind of the extreme side of the monetary value on these losses as a negotiation tactic that just sets expectations. So by way of example, you go out to a water loss, and really on the high end of things, this could go for $40,000. And you tell them that, say, look, this I think this loss is going to be upwards of 40 grand. And then all of a sudden, they give you their estimate, it's at 10, and you're coming down and saying, okay, look, I can be reasonable and get this thing done at 20. You look like you're a hero jumping down so far from your 40 when you actually haven't moved at all, because in crunching the numbers, you found it to be a lower number. Having that anchor in there actually makes a huge psychological difference, and you'll read a lot more about this if you read that Never Split the Difference book, but I found it to be extremely helpful. Use questions to get them to explain. So this one is relatively simple. Rather than telling an insurance company something about what caused the loss or what the damage is or why it's covered under the policy, ask them questions to get them to explain it to you. And the reason is most of the time when they actually try to do the analysis necessary to explain that kind of answer, they're going to recognize the flaws themselves. And if they can do that, if they can find the problem themselves without you telling them, the chances of them sticking to their old decision is slim to none, because they're going to be much more likely to be in your favor if you can get them to explain that away. Again, this is a super brief overview, but this stuff can go a lot more in detail, and I'm happy to discuss it with anyone who's interested. Last, join groups to discuss trends and get ammo for claims. This is a really big one because it's something that I think is severely overlooked by the industry. If you've got Jane Doe adjusting a claim for Allstate with, public adjuster 1 and then public adjuster 2, if adjuster 1 and adjuster 2 are in communications and they can say, oh, Jane Doe paid me for this on my claim, you could use that information to say, Jane, you've recognized this is covered in another loss, you have to pay it in mine. The truth is these carriers and their adjusters are really making independent determinations based off of factors they should never consider, like who the public adjuster is, what's the homeowner's situation, how well off are they or not, how likely are they to push back if I don't pay all these damages. So if you have information and can join groups that can give you kind of a backing for your position to show where they've done it in the past, use it. I mean, there's a ton of great information that other adjusters have, and I generally find the community as a whole is pretty good. There's some bad apples out there, and I obviously get that, but a lot of people in this industry are willing to communicate and provide that information. So you should absolutely be joining groups, whether that be on Facebook, which I'm sure a number of you have seen on my posts on Level the Playing Field, or the Good Fight, or Adjuster Attorney Portal. Any one of these is really a great community to be part of. All right. Oh, be the expert. I didn't even see it down there when I clicked it. The other aspect of this is you've got to remember you probably have more knowledge than whoever the insurance company adjuster is that was sent down. You're going to not only have to have a licensing exam and training and your CE credits every year. Adjusters on the inside, they don't have that. There's no requirement for a State Farm adjuster to have any of that. But if you're really getting into this and you find that you're getting some HEG certifications, IICRC certifications, whatever the case may be, you can be the expert so that you know what you're talking about when you're out there and can explain it to them. Explain to them in a kind manner exactly why this is covered. So to do that, to help you get there, you really want to read these books. When Words Collide is a fantastic book. Bill Wilson wrote a couple of years back, and it really does a fantastic job of analyzing policies, explaining some of the intricacies of insurance language. I mean, it's a must-read for anybody in this field. Never Split the Difference, a great book on negotiations that you should read. And you should all have in your library this dictionary of insurance terms. I don't know if you even knew that existed. I did a couple of years ago, and found it to be unbelievably helpful because you can cite to that anytime there's a question about policy language, and you can find that definition in there. It is an unbelievably good resource. So I'm going to push through some of these questions. The insurance adjuster changed the date of loss and peril from what was stated by the insured. The insurance company refuses to correct this to what they filed the claim for, how to correct this. Okay. Sorry, I did a copy and paste of the questions. I should have clarified this a little ahead of time. But if something like this happens where they're changing the date of loss and changing the peril, so this might happen in a storm claim where you've got water that enters through a roof, carrier wants to try to change it to a wind claim because there's a wind deductible on the policy, and that's not the proper claim because there's no wind damage you're claiming, you're just claiming interior water damage. So if that kind of things happens, this is some of the stuff that you'd have a good chance with the insurance department disputing. So the first thing you're going to want to do is document your complaint with the insurance company, right? So send the company a letter that clearly outlines, hey, this claim was put in as a water loss. It's been, changed to wind for reasons unknown. We're not making any claim for wind damage. In addition, the carriers changed the date of loss. The actual date of loss for this claim is X. We don't know why this has happened, but it needs to be remedied. Put all of that in writing. And then you can make a claim back to the insurance commission once you don't get a proper response. Use that insurance commission, the insurance department, to your advantage. They don't care about coverage decisions. They don't. The truth of the matter is if you think it's covered and the carrier says no, the insurance department's not going to get involved. What they want to get involved with is problems with the regulation. So not communicating timely, changing facts without basis or evidence. That type of stuff are the types of things that they will actually step in on. Clearly covered loss and insurance company is not responding. What do? You send a letter, and that letter should quote the local Unfair Claims Practices Act or Unfair Claims Settlement Practices Act as to their time frame to respond. To say, look, we've requested X, Y, and Z times for responses to coverage. You're required to give written responses within X number of days. You haven't done that. Please respond. In addition, you should be sending a hostile proof of loss. The hostile proof of loss, simply being a proof that wasn't requested, can be used to trigger a lot of timelines. I've got other talks on this in the past, so go back and you can watch some of those, but I don't want to spend too much time on it here. When it comes to proof of claim, which I'm assuming they meant proof of loss, how to use timing, strategy, point of use. So your proofs of loss can be a huge, huge advantage to the timing of your claim to get things moving. You want to use a proof of loss when the carrier isn't responding to you, isn't negotiating in good faith, and you're trying to get some real substantive responses. So you can send a proof of loss, usually has a 15-day response time based off of the local laws to have a coverage decision. And that's one great way to help speed up the process onto these claims. Other times, obviously, when it is requested, you want to have a proof of loss that is submitted. Anytime they request it, just get them a proof of loss. And on your FEMA losses, anyone that does FEMA, it's 60 days, right, Mario? 60 days for the FEMA proof that absolutely, positively must be sent in. Do not miss that timeline for the FEMA loss. I'm sorry?
And notarized.
And notarized. Sent in and notarized. The proof of loss issues with FEMA are completely different, and they're much more strict. So you want to make sure you are in compliance with that. 5 musts on every claim. Do this or don't complain. What would they be? There's a lot that I have, and I really like this question, but I do have a list. So this is really more of a summary. The truth is there's more than this that needs to be done. Based off of today's conversation, these are the things you're going to want to do. You get more bees with honey than vinegar. So truthfully, I really mean this. I think you should be the nicer person in these adjustments. I know there are people out there that feel differently, and they've just got such hatred for insurance companies. Trust me, I do too. I don't like them, but you just get further if you are being a nice person about this. Claim documentation, absolutely a must. If you don't have your claim properly documented with photographs, evidence, correspondence, and reports, you don't deserve to be paid. So get those things done every single time. Use the law regarding timing to your advantage, right? You want to make sure that you have an understanding of these response times so that you aren't letting claims just linger for months. I get calls from adjusters constantly where it's been 8 months and the carrier's not doing X, Y, and Z thing. There is, short of this being a massive commercial fire, there is really no residential claim that I can think of that should be lasting 8 months. There's just no reasonable basis for it. So you want to make sure that you're getting that as well. Always, always, always have a denial response letter. You always want to make sure that you are following up with that, because having that in writing, especially if you're going to continue to push on the claim, is an absolute must. Without it, you might as well just concede to whatever the denial is. Because a lot of times courts will come back and say, hold on, no one ever contested this. No one ever said that what they did was wrong. How could they possibly have been in bad faith if no one ever told them what they were doing was unreasonable? You always want to have that. Which comes to the last one of being reasonable. I understand maximizing claim value. I'm all for it. And I think homeowners should get the maximum amount of their claim whenever they have an insured loss. But that doesn't mean that it needs to be inflated just for the purpose of inflating it. A lot of times you can get these claims done if you can just be reasonable and make sure you are only pushing for what's really covered. I will see estimates where people make mistakes and they're not really legitimate mistakes. So you want to make sure that you are being the reasonable side at all times when you're adjusting these claims. OSHA, how, what, and when to provide documentation to support these costs. This one's actually relatively simple. Anytime OSHA comes into play, you're going to want to provide the documentation to the carrier as to why it's coming into play and why you're claiming it. You want to make sure you've got coverage for it, so make sure there's coverage for ordinance and law if you need it, or a lot of times people kind of mix up the ordinance and law coverage. That doesn't apply if it's simply a matter of repairability now. This comes up with stucco claims. For example, stucco can only be put on houses a certain way. You're not making a claim because of ordinance and law to repair the property. It's just how the property needs to be repaired regardless of what was on there before. Those are two different types of coverages. You're not triggering O&L simply because the stucco is put on a specific way. So same thing goes for OSHA. If you've got OSHA requirements that are being kicked in, you absolutely should be presenting them. And present them with the actual code. I mean, I know people have a tendency to just cite and say, oh, building code says X. Give them the code, cite the number, and tell them what it is, because that will go a long way. If OSHA requires, certain safety materials, put it in there, show them the code, and you should be able to be paid for that every time. The ones that I see not getting paid are the ones that just say it without any basis. Those are the problematic times. What about public adjuster notes being discoverable? Is that a concern? So your internal notes could arguably be maintained as part of anticipation for litigation, but it's not likely. It probably would be discoverable. But candidly, you shouldn't be having any concerns about what's in there anyway, because all you're putting is what you should be doing and what did happen in the loss, right? So if you've got a concern of something going into the log notes, you really should be asking yourself, well, why did this concerning thing happen, right? Is this something that needs to be put in the log notes? Is there a reason, some underlying reason it happened? Does it raise some other red flag? But short version is you're probably going to have this stuff discoverable, so just make sure you know that as you're updating these notes. Don't use profanities. Don't go cursing off your inside adjuster that you're working with, saying how much they're an asshole, even though we all know it's true. You don't want to necessarily put that in writing. Any recommendations for software? All right, so this one was tough, and I had a feeling someone might bring this up. I know some companies that use their own internal programs, and that takes a lot of money, and I don't necessarily recommend it. Claim Wizard, I've heard great things about. I've never personally used it. In our office, we have a software program called Practice Panther. It's a terribly cheesy name, but it does a pretty good job. And while it is directed towards litigation, from what I can tell, we've been using this for 4 years. There's nothing in there that wouldn't be useful to public adjusters as well. And it's pretty inexpensive. But Claim Wizard is a really great one that is specifically designed for public adjusters. If this is actually a concern for people, I'd be happy to do a little bit of research into this and give you my advice. I would be interested myself, so if I find a better answer, I'll let you know. But Claims Wizard or Practice Panther will probably do a good job for you. What do you do when an adjuster refuses to consider or even look at a line item they believe, in their opinion, is not relevant to the claim as a whole? Well, all you can do is document it, right? You can't force them to change their mind. And unfortunately, it just doesn't happen. That's why cases have to go to litigation. I don't want you here, can't stress that enough, but if you do need to be here, I'm happy to help, because you need to document this and say, look, I recognize that you're not looking at this line item. Now, let's just use a few examples. If it's because they say it's not damaged, show the line item, show a photo of the area that it's damaged, and say, look, this is why it's in here, this is why we're doing it. If you're doing it because it's necessary as a proper repair based off of code, say, look, not a code upgrade. This is necessary for the repair of code. Here's the code. Here's the damage. We've got to do it that way. If it's something they're saying isn't damaged because their expert disagrees, have an expert of your own. I mean, you really want to show that type of proof of being very specific between your line item and the reason it's in there. A great thing that a lot of adjusters have started doing is reaching out, if you're using Xactimate, to Xactimate Home Office in their chat function, and they will help answer questions about what's in Xactimate, what's being used. If you're not super familiar with it, use those resources, because you can use that as evidence to say, like, look, you're saying that in the ridge already is included in the slopes for a roof, and there's no waste for the ridge, or whatever BS they're coming up with. You can actually contact Xactimate to get some of that information from them as well. So there's a lot of ways to do it, but the short answer is specific response with specific proof. Is it okay to record the adjuster as he or she voices his or her opinion? That may be his or her opinion only. Can it be used against them later? Well, whether or not it can be recorded is a question for state law. So depending on your state and whether or not you provide them that notice is going to really determine whether or not you're allowed to do it. Assuming you are allowed to do it, absolutely it can be used later. If it's their opinion, they are acting as a representative of that insurance company and can absolutely be binding on that carrier. In one of my talks earlier, we talked about estoppel. and how that applies, but you can use this towards your estoppel arguments to say, hey, when we were together, you said this was going to be covered. My insured went out and signed up with a contractor, so now they're stuck into that contract. You're responsible for that because you told me it would be covered. What is the next step when the carrier refuses a second inspection following a partial denial? So documentation first. You want to send your letter explaining why it's necessary and what needs to be shown. You should also be quoting the Unfair Practices Act that says that they have to do any reasonable inspections of the property to determine the loss, yada, yada. So cite to that law as well. They really shouldn't be denying a second inspection. If they still refuse to do a second inspection, document a second inspection yourself. So go out and say, look, I did the second inspection without you. Here's a video of that and photographs. And based off of this, you need to change your position. The goal is to get them the information, whether they are willing to get it or not, right? So if they just want to say, no, we're not doing an inspection, we don't think it's helpful, it's because they don't want to see the evidence you want to show them. You need to show it to them anyway. That's your real goal. If they still refuse, you're going to have little choice other than taking it to the next level, whether that be litigation or appraisal. Those are really going to be your options. Again, a great class on appraisal that occurred in the past that you should check out. All right, thank you so much. I did this just in time that I'll be able to get everything together for my DEP. So if you guys have any further questions, here's my contact information. Again, it's bigger now. So if you didn't get it before, please take it down. Reach out to me anytime. I'm always happy to discuss this stuff. I really enjoy this area of work. So thank you guys so much. If you have comments, not only just about how this went, but about what you want in the future, please let me know. I'd love to know what kind of courses you guys would be interested in. Otherwise, I'll just keep picking and we'll keep going through it. All right.
There
Thanks,
was
guys.
one other question that came in after you got to the final slide there. How long should the average residential claim take place, in your opinion?
All right. So I assume people could hear Mario, but just in case they couldn't, how long should the average residential claim take? It's hard to say what an average residential claim is, assuming we're talking about, your $20,000, $30,000 roof water leak type cases. You're looking 2 to 3 months max. I can't fathom an actual reasonable justification as to why it would take longer than that. You've got a big fire loss, total loss where it's got to be inventoried. That can take some more time, 5, 6 months maybe. But if you're doing your part, and this is what's really important, if you're doing your job and following up and using the state laws to your advantage, then you absolutely should be able to get these moving faster, because that's what those regulations are there for. They are there to make sure the carrier doesn't just sit back and do nothing. So when they've got 10 days to respond to a letter, use it to your advantage. They've got to make a claims decision within 15 days of a proof, use it. That's the type of stuff that gets these things moving along. All right. Thank you so much, everybody. We will talk soon. Take care.